May I now request the Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud, to please share his thoughts with us on this special occasion.
Namaste. Honorable President of India, Srimati Draupadi Murmuji, Honorable colleagues, my own brother and sister judges of the Supreme Court, including my senior-most colleague, Justice Sanjeev Khanna, Justice Suryakant, Shri Arjun Ram Meghwalji, the Minister of State for Law and Justice, Chief Justices of the High Courts, the Attorney General for India, Mr. R. Venkatramani, the Solicitor General, Mr. Tushar Mehta, law officers, judges of the District Judiciary, members of the Supreme Court Bar Association, the Supreme Court Advocates on Record Association, distinguished resource persons, and all the guests present here. Almost 75 years ago, the axis of the earth aligned itself a little more closely with the axis of justice. India, 1/5 of the human race, gave itself a democratic and republican constitution. A constitution which promised to digress from the path of a hierarchical and discriminatory society governed by colonial oppression. A constitution which would modernize the country and champion social justice through a democratic and peaceful process. A constitution premised on the timeless principles of justice, liberty, equality, and fraternity. Our constitution was an amalgam of the experiential and the aspirational, of stability and change. The constitution also established the judicial branch of government. As we mark the 75 years of the founding moment of the constitution and the establishment of the Supreme Court of India, we pay tribute to the role which the judicial branch of government plays in meeting the aspirations of the citizens. Henry Longfellow, the celebrated poet, had said, "We judge ourselves by what we think we are capable of doing. Others judge us by what we have done." I firmly believe that our actions must give others a reason to judge us favorably. But our intention and capability must incentivize us to excel higher and higher. In an institution as integral to the life of a nation as the judiciary, complacency is not an option. The National Conference on the District Judiciary has provided us with an honest opportunity to reflect on our journey so far and plan for the future we envision for the judiciary. We, the members of the judiciary, and the members of the district judiciary in particular, are vital stakeholders in this endeavor. I have been heartened to see the members of the district judiciary, the registrars general of the high courts, and the chief justices of the high court share their insights with a sense of camaraderie, equality, and candor. Their innovative ideas and unique experiences of life make this conference interactive and holistic. I shall therefore speak briefly on the subjects of our discussion over the last 2 days with 3 things in mind. Firstly, I will trace our progress so far. Secondly, I shall highlight the deliverable outcomes which we aspire to achieve as a result of the deliberations at this conference. And lastly, I will briefly speak on the way forward. Justice delivery is an essential service which we provide to our citizens, especially the most vulnerable. Efforts in the past decade have modernized our judiciary, aiming for a tech-savvy and accessible infrastructure such as trained personnel, spacious court complexes, facilitation centers, e-seva kendras, medical facilities, and creches. Just yesterday, or actually day before, we inaugurated a new creche, enhancing the capacity of our existing creche, which was about 20 young infants, to over 100 infants. That reflects the changing demographics of the Indian judiciary. the young are progressively taking over the reins. These developments have a direct impact on our ability to reduce pendency. Our current national average disposal rate stands at 95%. Despite progress, tackling pending cases remains a challenge. Increasing our disposal to filing ratio hinges on attracting skilled personnel. At the district level, vacancies in judicial personnel stand at 28% and of non-judicial staff at 27%. In order for disposals to outweigh the institution of cases, the courts must work beyond the capacity of 71% to achieve 100%. To fill the vacancies, the conference deliberated upon the criteria for selection of judges and standardizing the recruitment calendars for all vacancies. The time has really come now to truly think of national integration by having a recruitment to the judicial service which crosses the narrow domestic walls of regionalism and state-centered selections. The Committee on Reducing Arrears of Cases, chaired by Brother Justice Abhay S. Oka and consisting of Brother Justice Vikram Nath and Brother Justice Dipankar Datto, have skillfully laid out an action plan for reducing case pendency through case management. The 3 stages of the action plan include: first, the preparatory stage of forming district-level case management committees to identify target cases, undated cases, and reconstruction of records. The second stage, which is ongoing, aims to resolve cases which have been pending before the courts for 10 to 20 years, 20 to 30 years, and more than 30 years. And third, from January to June 2025, the judiciary shall execute the third phase of clearing the backlogs of cases pending for over a decade in courts. This effort requires an intricate coordination of various applications and data management systems to plan and track our strategies. Some of the other strategies of dealing with the backlog include pre-litigation dispute resolution. The Supreme Court of India recently concluded its first ever National Lok Adalat, at which almost 1,000 cases were disposed of amicably within a course of 5 working days. There is no reason for cases which can be settled between the parties to languish before the courts for lengthy periods of time. The courts undoubtedly are a forum for upholding the rule of law and dispensing justice under the law. However, alternative strategies such as Lok Adalats and mediations provide us with an avenue to introspect whether an adversarial proceeding is even required between the parties. Further, addressing infrastructural gaps requires a strong government-court partnership. Coordinating with High Court's infrastructure committees and integrating engineering and research and development can expedite projects for a future-ready judiciary. We must, without any question, change the fact that only 6.7% of our court infrastructure at the district level is female-friendly. Is this acceptable today in a nation where, at the basic level of recruitment in some states, over 60 or 70% of the recruits are women? Our focus areas are on increasing accessibility measures, which can be understood by carrying out infrastructural audits, opening in court medical facilities, creches, and technological projects like e-Seva Kendras and video conferencing devices. These endeavors aim to increase access to justice. Axiomatically, we must also ensure that our courts provide a safe and accommodating environment for all members of our society, in particularly for groups such as women and other vulnerable groups such as persons with disability, members of the scheduled castes and scheduled tribes, and people across the socio-economic landscape. With the increasing number of women coming into the judiciary, we must also confront the biases which we may unwittingly have towards our colleagues at the bar and the bench. Being a judge at its heart is a calling to dispense justice. To this end, we must consciously introspect that our legal reasoning does not wield the mighty hand of the law to perpetuate existing prejudices. Inclusivity in the judiciary is a reflection of our broader commitment to equality and justice. Some key measures in this endeavor are: 1. Developing a comprehensive framework for gender equality in decision making. 2. Adopting measures to recruit, train, retain, and promote members from diverse and vulnerable groups. And 3. Monitoring the impact of gender equality initiatives. The well-being of our judges, both personal and professional, has a vital stake in the overall health of our judicial institution. Judges deal with distress, and that distress affects them mentally and physically. Addressing this issue requires us to recognize the unique stressors of judicial work, enabling a robust support system, and prioritizing mental health and wellness initiatives. We must start by destigmatizing the conversation around mental health and foster an open and supportive environment for our judges to function. Judicial wellness is not a personal concern, but a democratic imperative for upholding the rule of law and maintaining public confidence. It is with that view in mind that yesterday we had one whole session developed on the lines of judicial wellness, at which the head of the government's flagship project, the Ayush Hospital at Sarita Vihar, Dr. Tanuja Nesari, gave us words of wisdom and her knowledge. The Center for Research and Planning of the Supreme Court of India has been preparing a white paper to integrate the state-level training modules of the State Judicial Academy with national and international best practices. Currently, some of the courses at the State Judicial Academies have a robust curriculum, while the others focus on re-engaging a newly qualified judge with law subjects. We are in the process of setting up a systematic, nationwide curriculum for judicial training and harness technology to track our progress. The new curriculum promises to bring innovative training methods, a thematic framework, uniformity in training calendars, integrating judicial training with information technology, recasting the National Judicial Academy to fill knowledge gaps, and most importantly, to establish a feedback and assessment methodology. I've always believed that our practices and initiatives must be institutionalized. It is often difficult to ensure that our practices are not just a one-off endeavor like this conference, but become native to the institution. When it comes to judicial training, we have periodically seen the curriculum being updated. However, now it is time to truly harness our best practices and ensure that every last judicial officer is a beneficiary of the best which we have to offer through innovative pedagogical approaches. Finally, the perceived gap between the district judiciary and the high courts must be bridged. This gap is a product of colonial times, of colonial subordination. Primarily, these gaps have been identified in collegiality between the judges, the role of the inspecting or administrative judge, and assessment of judicial officers. Collegiality is the willful sharing of authority between colleagues. An environment of open, frank, and holistic communication between judicial officers and high court judges is vital in achieving fair transfer policies, equitable distribution of work, and transparency in promotion and assessment. Inspecting or administrative judges must ensure that their process of evaluating judicial officers is based on data collected over a period of time and not through mere inspections on designated days. The purpose we seek to achieve by this is to instill a sense of ownership and belonging in members of the district judiciary who are entitled to be judged based on their long-term and consistent performance. The district judiciary is the backbone of our institution. These last 2 days have allowed us to revisit the state of the judiciary and deliberate upon constructive solutions which could be acted upon in the immediate and long-term future. It is my sincere belief that conferences like this allow us to evaluate and collectively articulate the state of the judiciary in India. Respected President of India, it is with utmost humility that I share with you that the state of the judiciary in India is strong, and its strength comes from the district judiciary. Talented young lawyers, particularly women professionals, are being recruited to the district judiciary in large numbers. They represent the changing demographics of a confident India. The task now is to realize their aspirations, to harness their dynamic spirit of young professionals, to challenge injustice, to face up to discrimination, and realize the transformative ideals which have led them to adopt judging as a way of life. 2 years ago, the Honorable President of India emphasized the need to declog our jails, declog them by not keeping petty criminals indefinitely behind bars. Those words of the Honorable President ring true today, and it is with that hope and aspiration that we had tried to inculcate a sense of independence and confidence, free of fear, in the minds of our young judges, that they shall be protected by the system, despite the fact that they retain their fierce independence. All along, while creating safe and optimal working conditions and conditions of service which provide dignified conditions of work during and after service in the judiciary. Providing proper working conditions for the district judiciary is a small price which the nation pays for securing their independence and impartiality. A financially insecure judiciary will be a grave danger to a stable democratic society. I hope that each one of